everyone, welcome to this session on submitting late applications to the EU settlement scheme. My name's Hannah Smith and I'm a lawyer at the EUSS Centre, and I'm joined by my colleague Ellie Sibley, who's a barrister at Field Court Chambers, but she's happily on secondment to the EUSS Centre as well, working with us on our EU settlement scheme projects. So today we're going to do a very brief overview of the EU settlement scheme, as I'm aware you probably all already know what it is and some of the relevant deadlines. And then we're going to look at the circumstances in which EA citizens and their family members can make a late application to the settlement scheme, and some of the situations in which they may not be late, so where the deadline has still not passed for certain applicants. We'll also look at some of the evidence needed to support a late application and the actual process of making a late application, and have a look at these new 28-day notices which the government are handing out to people they encounter who have not applied to the scheme, and the importance of taking quick action in response to these notices. So very briefly to start with, as I'm sure you're aware, the EU settlement scheme is the new immigration scheme and status which enables EU citizens and their family members to remain in the UK lawfully after Brexit. And the deadline for most applications was the 30th of June 2021. But there are certain exceptions, for example, for joining family members and those applying under the Surinder Singh route, which we will discuss in more detail later. So settled status is indefinitely to remain in the UK, and holders of settled status can enter, re-enter, live in the UK, work in the UK indefinitely, and spend up to 5 consecutive years outside the UK without losing this status, and have the same rights to live, work, access benefits, etc. in the UK as UK nationals. Pre-settled status is limited leave to enter and remain in the UK for a period of 5 years, and holders of pre-settled status must apply to upgrade to settled status after they have lived in the UK for 5 years and before the expiry of their pre-settled status. So this just sets out who exactly needs to apply for settlement or pre-settlement in the UK. Relevant EEA citizens who were resident in the UK before 11 PM on the 31st of December 2020, family members of such EEA citizens. Generally, they also need to have been residing in the UK before the 31st of December 2020, unless they are close family members who can then apply to join their family members after this deadline. People with a derivative right to reside or a Zambrano right to reside, so generally primary carers of EU national or British national children. Family members of qualifying British citizens, who are the Surinder Singh cases we'll discuss in more detail, and family members of relevant naturalised British citizens, so those family members of dual British EA nationals who exercised free movement rights in the UK before naturalisation, but retained their EA nationality after acquiring British citizenship. So the conditions for settled and pre-settled status are that a person to apply for settled status must have lived in the UK for a continuous qualifying period of 5 years, and that means residence that began before 11 PM on the 31st of December 2020, although there are some people who can qualify sooner than 5 years, for example, somebody who is the family member of a person who was working in the UK and then died after their period of work in the UK. And for some people, for example, joining family members and some Surinder Singh family members, this continuous period of residence can begin after 11 PM on the 31st of December 2020. And people also need to pass a suitability assessment, often based on their criminal record in the UK. And we will be delivering another webinar on the suitability assessment and people with criminal records and who are in prison applying to the EU settlement scheme, if that's of interest to anyone. And then those applying for pre-settled status are those who would be eligible to apply for settled status but have not yet completed the 5 years residence test. So moving to look at the deadline, The main deadline for a person to make their initial application to the EUSS was before 1st of July 2021, unless the Secretary of State is satisfied by information provided with the application that there are reasonable grounds for the person's failure to meet the deadline. And this particular deadline applies to EEA citizens and their family members who were in the UK before 11 p.m. on 31st December 2021. Any joining family members who arrived after this date but before the 1st of April 2021, people with derivative rights to reside, although there are maybe certain exceptions for Zambrano carers, which Ellie will talk about later, and certain Surinder Singh family members. So that's the extended family members of qualifying British citizens, or those whose family relationship with their British citizen was formed between 11 p.m. on the 31st of January 2020 and the 31st of December 2020, and who returned to the UK prior to the 31st of December 2020, unless they are the child of a qualifying British citizen or their spouse or civil partner who was born after 11 p.m. on 31st of January 2020. So we'll talk about Surinder Singh family members in a bit of detail, and essentially there are these two categories of family members of British citizens: those whose relationship was formed before what's known as the withdrawal date, i.e. 31st of January 2020, and those whose relationship was formed after. And there are slightly different rules which apply depending on when exactly this relationship was formed. So for those whose relationship was formed after the 31st of January 2020, they need to have arrived back in the UK before the 31st of December, and their deadline is this main deadline of 1st of July 2021. The other deadline to be aware of is the deadline to upgrade from pre-settled status to settled status, and this is defined as before the expiry of pre-settled status. So everyone will have their own personal deadline depending on when they applied for pre-settled status in the first place. And again, this exception applies where that's the deadline unless the Secretary of State is satisfied by information provided that there are reasonable grounds for the person's failure to meet the deadline. So what are some of the exceptions to this main deadline? Firstly, the deadline for joining family members of a relevant sponsor is within 3 months of their arrival in the UK, if they arrive on or after the 1st of April 2021. And that applies indefinitely for joining family members. So they can come to the UK at any point, so long as they can prove that their relationship with their EU national family member existed before 31st of December 2020. And then when they arrive, they have 3 months from the date of their arrival. And this is quite an important date to bear in mind, because joining family members who apply with an EUSS for an EUSS family permit to come to the UK may have 6 months to enter and live in the UK lawfully, because the EUSS family permit is generally valid for 6 months. So even though they have this permit valid for 6 months, the deadline to apply to the EUSS is 3 months from their date of arrival. And again, unless there are reasonable grounds to apply late. There's another exception to this, which is if they are the spouse or civil partner of a Swiss national in particular, in which case they have a separate deadline. But for most joining family members, they must apply within 3 months of their arrival. And then otherwise, the other category is this other category of Surinder Singh family members. So this is the people who formed their family relationships, so their marriage, civil partnership, durable partnership, prior to the withdrawal date of 31st of January 2020. They can return to the UK and apply for EUSS at any point before 11 p.m. on the 29th of March 2022. And again, that's the deadline unless there are reasonable grounds to apply late. And that is also the deadline for a child born or adopted, or who becomes the child of a qualifying British citizen after 11 p.m. on 31st of January as well. The joining family member of a relevant sponsor who is the spouse or civil partner of a Swiss citizen, again has this 3 months of arrival within the date of arrival to apply. but they must apply before the 1st of January 2026. So in this specific case of a Swiss spouse or civil partner, they need to apply and arrive before January 2026. And then another exception is people with limited leave to enter or remain under another part of the immigration rules. So if somebody's been granted a visa, for example, or leave to remain not based on the EUSS, and that leave to remain remains valid, then they have until the date of the expiry of that leave to apply again, unless there are reasonable grounds to apply afterwards. And finally, someone who ceases to be a person exempt from immigration control on or after 1st of July has 90 days from the day on which they cease to be exempt from immigration control to apply. So this is what Appendix EU specifically says about making a late application, and that's where the Secretary of State is satisfied by information supplied that there are reasonable grounds for missing the deadline. The required date, i.e. the date by which they must apply, is after the given deadline. So for example, that's after the 1st of July for the people who that deadline applies to. And this exception is made, as we've already said, in respect of every set deadline that Appendix EU provides. There's quite detailed guidance in the Home Office caseworker guidance, which there is a link to in this slide, on situations in which there might be reasonable grounds for missing the deadline. And there are some key points from the guidance there, which we're going to go through in turn in the next slide. But essentially, any application made after the specified deadline for that type of application, so for most applications after the 30th of June 2021, need to include an explanation of why the application is being submitted late. So the guidance provides that the ability to apply to the scheme exists indefinitely. So a person can apply in 5, 10, 20 years, as long as they meet the requirements of the scheme, it's open to them to apply indefinitely, as long as they can explain why there are reasonable grounds for their failure to meet the specific deadline applicable to them. However, it is important to apply as soon as possible, and there are a number of reasons for that. So a person will need to secure their status to secure rights to live, work, rent, have a bank account, access healthcare, access benefits, etc. in the UK, and essentially to avoid the risk of being removed from the UK to show they have a lawful right to be here. Additionally, the guidance suggests that the more time which has passed since the deadline, the harder it might be for them to satisfy that there are reasonable grounds for their failure to meet the deadline. And there are certain exceptions to this. So for example, the guidance provides that where an applicant was a child at the time and somebody failed to make an application on their behalf, they should always have reasonable grounds to make an application late. But generally, the more time that passes, the harder it will be to convince a caseworker to accept the reasonable grounds. Further, the Home Office has indicated in this guidance that for the time being, they will give the applicants the benefit of the doubt in considering whether there are reasonable grounds for their failure to meet the deadline. And they've kind of indicated that there'll be this grace period after the deadline where they exercise the benefit of the doubt, but it's not clear how long this will be. They haven't given any indication how long they'll exercise this approach. They have simply said any change in approach will be reflected in a revision of this guidance. So particularly whilst we don't know how long this period will last and this approach will last, we would say to make an application as soon as possible while they are exercising this approach. So in every case, the basic requirement is to show that there are reasonable grounds to make a late application. And this is quite a broad test. The guidance contains some specific examples as to what might constitute reasonable grounds, but they are by no means exhaustive. And certainly any person that comes to us for advice at the moment, we would advise them to argue there are reasonable grounds for missing the deadline based on whatever their circumstances were, because this definition is not exhaustive. The Home Office caseworkers are directed to apply a flexible approach and to look for reasons to grant status and to accept that there are reasonable grounds for making a late application rather than to refuse. So they're really told to exercise this approach in favour of accepting reasonable grounds rather than saying that a person should have met the deadline and rejecting their application as a result. So that's the general approach that provided for in the guidance. In terms of what happens for where a person is encountered by immigration enforcement if they have not yet made an application, the guidance provides that a person should be given a notice informing them of the need to apply. So if someone's encountered by immigration enforcement and that enforcement officer considers that they might have been eligible to apply, whether as a family member, as an EEA citizen, or as a joining family member, then they should be given this written notice and given the opportunity to make a valid application. The notice period will normally be 28 days and it should be recorded on the Home Office system so that during this time it's clear that no enforcement action, for example, no moves to remove this person should be taken. If the person makes a valid application under Appendix EU, then they will consider the application as normal, looking for whether there are reasonable grounds for the late application, and then going on to consider their eligibility and suitability criteria in line with the relevant rules. If the application is invalid, so for example, if it's missing evidence or made using the incorrect process, then the applicant should be prompted and they should be given an opportunity to validate it. If after this they fail to validate the application, it will be rejected, and there is no right of appeal for an application which is rejected on the grounds of being invalid. So what we would advise is to try to apply before this notice period expires, even if a person is lacking evidence. So to submit the application with the evidence they have, with the ID documents that they have, and to potentially also upload a letter which explains that evidence is missing and that it's on its way, and explaining the steps being taken to obtain it. And then in line with the guidance, the person should be given reasonable opportunity to provide further evidence. And the Home Office should contact them and try to work with them to help them to obtain that extra evidence. So if you come across a person who's been given this 28-day notice, we'd advise that you check as soon as possible if they have evidence of ID or of their nationality, or whether they might need to request a paper form, or whether they would need to request a paper form for any other reason, for example, because they're applying as someone with the derivative right to reside, as a Zambrano carer, etc., and get that paper form requested as soon as possible. After the expiry of the 28-day notice period, following the guidance, the person would be at risk of immigration enforcement action and removal from the UK. But if they do make an application after this 28-day period, we would say that the Home Office should still consider that application in line with their guidance. So they should still consider if a person has reasonable grounds to make it and if they meet the other conditions. And then if they do have reasonable grounds for the late application, that this application should still be submitted. So obviously the guidance provides that someone can apply to the EUSS indefinitely, and there are provisions of the withdrawal agreement, for example, Article 18(1)(d), which enforces this and which says, that they should be given a further reasonable period of time to apply. So whilst the Home Office might be issuing these 28-day notice periods to encourage people to apply when encountered following the relevant provisions, we wouldn't necessarily say that there should be anything to stop them from applying after the 28-day notice period has expired. However, to be on the safe side, we would suggest submitting something before the expiry of this 28-day notice period, because obviously this is a new area and no one has that much experience knowing what would happen after the cut-off period has expired. So when a person makes a late application, the application form will ask, why are you applying after the deadline? And there'll be a certain number of tick boxes to choose from, which we have a picture of on the next slide. And then they will be asked to provide information on their reasons for applying after the deadline. So on the online form, this is quite a small box. You can't actually write that much detail. So we would say, write what you can in that box, but then upload as evidence later in the application a much more detailed letter which sets out all of the reasons why the person is making a late application, and alongside submitting evidence of that. So these are the specific boxes that a person is able to tick, and you can only select one on the online form. So it may be that quite a few apply to a person, but in that case, you can select whichever is the most relevant and then explain the other factors which apply in the supporting letter as supporting evidence. As well as explaining what the reasonable grounds is, as we've said, we would also need to upload evidence of reasonable grounds for missing the deadline. If an applicant hasn't provided this evidence, they should be given the opportunities to submit this, and their guidance provides that the caseworker dealing with their case should engage with the applicant and inform them that they need to provide further evidence before the application is rejected. If the Home Office finds that there are reasonable grounds for missing the deadline, then the application should be considered in the same way as any other. And the Home Office should take the flexible, pragmatic approach and work with the applicant to assist them to evidence their right to status and their eligibility. So as soon as they're satisfied that there are reasonable grounds, they go on to consider the application as normal, and it's not considered in any different light because it was submitted late. And any further evidence they need, the applicant should be prompted and given a reasonable opportunity to provide it. If an application is refused on the basis that there weren't reasonable grounds to apply late, then this is an eligibility decision rather than a validity decision. Reasons should be provided, and there is a right to seek administrative review or to appeal this decision to the tribunal. And there's guidance on this on pages 33 to 34. Where an applicant has already made a late application with reasonable grounds for failing to meet the deadline, and the application is refused, the guidance does provide that they will not normally be able to establish that they have reasonable grounds to make a second late application, but it does depend on all the circumstances of the case, and it may be worth a go depending on the exact circumstances of that case. So we have now set out in a bit more detail some of the examples of situations in which there'll be reasonable grounds to apply. As I've already said, these are not exhaustive, so it is definitely worth arguing a different ground if you think that's a reasonable ground for your client to have missed the deadline. But I'm going to hand over to Ellie, who can provide some further detail on specific situations in which a person might apply late.
Thanks, Hannah. Can you hear me?
Yes.
Great. Okay. So as Hannah said, we're now going to go through some specific examples set out in the EUSS guidance of cases where people either will or will normally be found to have reasonable grounds for making a late application. The first of these is children, including children in care or care leavers. And what the guidance says is that there will be reasonable grounds for making a late application where a parent or guardian or local authority has failed to make an application on behalf of a child aged under 18 before the relevant deadline, or where a local authority has failed to support a care leaver to apply. And that applies even when the child is now an adult. So the Home Office accepts that in the case of people who were children at the time that the relevant deadline applied, or who were care leavers, it may be months or even years before the person realizes that they need to make an EUSS application. And so in this circumstance, the Home Office is likely to offer quite a big degree of latitude and allow applications to be made late for kind of many months or years into the future. However, it's still important to make the EU settlement scheme application as soon as possible in order to secure the child's rights. So just moving on to the next slide. The Home Office guidance gives some examples of why an application may not be made on behalf of the child. However, just moving on to the next slide, those aren't really terribly relevant because the guidance also says that there's no need for Home Office caseworkers to inquire into those reasons. So if you have a child whose parent or guardian or local authority, if they were in care, didn't make an application by the deadline, that in itself is enough for there to be reasonable grounds. It doesn't matter why they didn't do it. And the guidance says that a late application can be made by the child themselves, whether or not they are now an adult, or if the child is a minor, so the person who was a child is still a minor, then the application could be made by a parent, guardian, or if the child remains a looked after child by the local authority. Just a note of caution in terms of particularly of local authorities making applications for children. They might need to consider whether they need to be regulated by the Office of the Immigration Services Commissioner, because it can be an offence for people who are acting in a professional capacity, whether or not they're paid for that work, to provide immigration advice and services unless they're regulated. But the Office of the Immigration Services Commissioner has said that where a local authority has got parental responsibility for the child, then it doesn't need Office of the Immigration Services regulation approval or any other approval from other regulated bodies, because they're acting as a parent. So they're not making it as a local authority, they're making it as a parent, and a parent wouldn't need to be regulated. Anyway, that's a little bit of a deviation from the main topic, but just to flag that. So moving on to the next slide. Whenever an application for a late application is made, you need to provide evidence that there are reasonable grounds. There's no express guidance from the Home Office on the evidence required for children or care leavers, but depending on the circumstances, we think that it should be sufficient to provide evidence that the applicant was under 18 at the time, so their birth certificate or other form of identification, because if they were under 18 at the time and no one made an application on their behalf, then that should be sufficient for there to be reasonable grounds. But you might also want to think about getting a letter from a local authority if the child was in care or as a care leaver, just explaining their circumstances, or even the applicant themselves could provide a letter. So the next category of people that are dealt with by the guidance is people who have who lack the physical or mental capacity to make an application for themselves, or did so in the months leading up to the deadline, or who have care and support needs, or did in the time leading up to the deadline. And the Home Office guidance makes clear that this doesn't just include adults who entirely lack the mental or physical capacity to make an application for themselves, but also adults who've got broader care or support needs, such as those who are residing in residential care or receiving care at home, and those with long-term physical or mental disabilities. If we go on to the next slide, you can see some examples that are included in the guidance. And just looking at example 2, this is about someone who was 80, lived in a care home, was not aware of the EU settlement scheme until a member of the staff at the home mentioned it to her. The member of staff helped her to complete an application herself in October 2021, so a considerable period of time after the 30th of June deadline. And this guidance says that in those circumstances, it would be accepted that there are reasonable grounds for that person missing the deadline applicable to her and making a late application. So moving on to the next slide, again, evidence would need to be provided that the person lacked the mental or physical capacity to apply or had care and support needs at the relevant time. And examples of this guidance are set out on pages 37 to 38 of the guidance. I won't go through those in detail now, but you can come back and look at those yourself. The next category of people that are covered by the guidance is people who have a serious medical, who in the months before or around the time of the applicable deadline had a serious medical condition, or were undergoing significant medical treatment. And on page 38 of the guidance, it says that this includes, for example, illnesses including COVID-19 or accidents that meant that the person was hospitalized or bedbound, but also illnesses or accidents which otherwise meant that the person was unable to perform day-to-day tasks. And the guidance in this section, even though you might not think of it, I might not think of it as an illness or a medical condition, says that kind of pregnancy and maternity might also be a reason why a person needs to make a late application. For example, if they had a difficult childbirth or their newborn child needed medical treatment. And if somebody has a serious medical condition or had significant medical treatment in the months leading up to or around the time of the applicable deadline, then this can also be reasonable grounds for someone who was dependent on them to make an application for them, also making a late application. So for example, if you've got somebody who was going to make an application for her sister who had care and support needs that meant she couldn't make an application for herself, and then that person was prevented from making the application for her sister because of serious medical condition or significant mental treatment, then that should be reasonable grounds for the sister. And this slide just gives some examples of situations in which this particular scenario might apply, and I'll let you read them in your own time. So again, there's a need to provide evidence in support of this ground for making a late application. The EUSS guidance says at page 39 that this could be a letter from a doctor or other health professional confirming the circumstances, or a letter from a carer, legal representative, or other appropriate third party confirming the circumstances. The next category of people who might be covered by reasonable grounds are victims of trafficking. So what the guidance says is that where a person was prevented from applying before the applicable deadline for them, because they may be a victim of modern slavery, that will normally constitute reasonable grounds for making a late application. In terms of establishing that someone is or may be a victim of trafficking, the guidance says that if they have a positive reasonable grounds or conclusive grounds decision, so they've been referred into the national referral mechanism for victims of trafficking, and the Home Office has made a positive decision that there are reasonable grounds to suppose that they may be a victim of modern slavery, or a decision that there are conclusive grounds for finding that they are, then that's enough to show that they are or may be a victim of human trafficking. And the Home Office caseworker shouldn't require any evidence beyond this, although they will also go on to consider whether that prevented the person from making an application on time. If there's no positive, reasonable, or conclusive grounds decision, but the applicant provides information with their application that suggests that they may be a victim of human trafficking, then the guidance says the Home Office should refer them to the local safeguarding team, presumably with a review to a national referral mechanism referral being made, if appropriate. The guidance says, though, that the Home Office caseworker who's looking at this late EUSS application doesn't need to wait for the outcome of the NRM referral, the National Referral Mechanism referral, if they decide that that person, the applicant, has got other reasonable grounds for making a late application. I think it's arguable that if the applicant provides sufficient evidence for the caseworker to conclude that they may be a victim of trafficking, then the caseworker shouldn't wait or shouldn't need to wait for a reasonable or conclusive grounds decision, even if the applicant doesn't have any other grounds for making a late application. But that's not what the guidance says, but I think you could definitely argue that. Then the Home Office guidance sets out various factors which it says are relevant when considering whether someone had reasonable grounds for missing the applicable deadline, where they may be a victim of human trafficking. Those include the length of time since the alleged incident, and any reasons for a delay in making the application. So, for example, the person's employer or trafficker retaining their passport or other identity documents, or failing to tell them about their immigration status. Factors also include the fact that the person, the applicant, may not have realised that they were a victim of modern slavery, or may not have known how or where to get support. The guidance also says that caseworkers should look at previous immigration history, particularly where there's evidence that the person has made a number of unsuccessful attempts to secure leave to remain in the UK on different grounds. And I think the implication here is that, well, if they have, then maybe they're not really a victim of trafficking. I don't think that that should be held against them if there's sufficient evidence that they are or may be a victim of trafficking. Then just moving on to the next slide, this just sets out an example that's given in the guidance of somebody who may be a victim of human trafficking and how that would be approached. And I'll let you read that in your own time. Again, there's a need to provide some evidence if you're making a late application on this basis. So if there is a positive reasonable grounds or conclusive grounds decision, then that should be supplied. The Home Office guidance doesn't really say much about what to do if there is no positive, reasonable or conclusive grounds decision, but we would suggest that whether or not there is, it would be sensible for victims of trafficking to provide a cover letter explaining the circumstances, highlighting that the person is a victim of trafficking, and setting out their circumstances. Could also provide a supporting letter from ideally, I guess, an authority that's made a national referral mechanism referral, or an organisation or professional who's working with the applicant in a professional capacity, who's assessed them as a potential victim of human trafficking. And any other corroborating evidence that you can provide, which is actually often lacking in the case of victims of trafficking and modern slavery. But if there is any corroborating evidence, such as, for example, text messages or email exchanges with traffickers, that could be supplied as well. But I wouldn't suggest delaying too long for supporting evidence, because if they make an application with the evidence that they have, and the Home Office doesn't think that's sufficient, they should be given a reasonable further opportunity to provide that evidence anyway. The next category of people who might have reasonable grounds are people who were prevented from applying before the deadline because they're a victim of domestic violence or abuse, or were otherwise in a controlling relationship or situation that prevented them from applying. And the Home Office guidance says that the caseworkers in the Home Office, when considering this, should adopt a flexible and pragmatic approach, considering each case in light of its particular circumstances. And it highlights that abusive and controlling relationships can take many forms. So that's quite helpful. And it's quite helpful to point that out if you are making a late application on behalf of someone who is a victim of domestic violence or abuse. Just moving to the next slide. Again, the Home Office sets out factors in its guidance that will be taken into account when assessing whether this ground for making a late application applies. And again, they include length of time since the alleged incident or incidents of domestic violence or abuse, and any reasons for the time taken to make an application. The fact that the person might not have realised that they were experiencing domestic abuse, or may not have known how or where to get support. The fact that the applicant and the perpetrator may still be living at the same address may not necessarily be taken as an indicator that their relationship has not broken down permanently, because there might be many reasons why they would stay in that relationship. Just pausing there, I don't think there's anything in the late applications guidance that suggests that in order to benefit from this ground for making a late application, you would need to show that your relationship has permanently broken down as a result of domestic violence anyway. All you need to show that is that you were prevented because you were in an abusive or violent relationship, not that your relationship has necessarily broken down. But I guess the point here is that you shouldn't discount someone as a victim of domestic violence or abuse just because they're still in the relationship. And so hopefully Home Office caseworkers will take that on board. Then again, the guidance says that immigration history might be taken into account. So once more, it's necessary to provide evidence in support of this ground. So you need to provide evidence that the person was in an abusive or controlling relationship or situation. The Home Office guidance has got quite a lot to say about this. First of all, it emphasises that neither Appendix EU nor any other part of the immigration rules specifies any mandatory evidence to be submitted to demonstrate that the person has been a victim of domestic violence or abuse. So, and each case has got to be considered in light of its own circumstances. And the guidance links to separate Home Office guidance on victims of domestic violence and abuse. But it says that this guidance is not exhaustive. And in each case, you've got to look at all of the available information and evidence to make a decision in the round. And the EUSS guidance also says that caseworkers have got to take a flexible and pragmatic approach and consider each case in light of its own particular circumstances. So just looking at the next slide, the Home Office guidance on victims of domestic violence and abuse, and there was a link to that on the last slide, has got a table on pages 22 to 29 of examples of evidence that might be considered to be conclusive, strong, moderate, or weak. And I've set out some of those on the following slides. But I think it's really important to remember in this context that the Home Office should be looking for reasons to allow the late application, and it should adopt a flexible, pragmatic approach. And the domestic violence guidance should not be taken to be exhaustive in this context. And so, for example, and we'll go on to look through some of these examples of evidence, but for example, the table in the domestic violence guidance suggests that a statement from the applicant themselves would be taken as weak evidence of being in an abusive or domestic, of having been a victim of domestic abuse or domestic violence. But at least so far as making late applications are concerned, there are lots of other situations set out in the guidance where the EUSS guidance says the applicant writing a letter themselves would be enough, would be sufficient evidence. And I think that should apply in the context of domestic violence as well, at least for the purposes of showing that someone's got reasonable grounds for making a late application. Okay, so this slide just sets out some of the types of evidence that the Home Office will consider to be either conclusive or strong. So that's criminal convictions relating to domestic violence, police cautions, a final non-molestation order or occupation order, and there are various other things set out here as well. I won't read them all out here, but I think one useful thing might be if you can provide a letter from social services or an organisation that has assessed the applicant as being a victim of domestic violence and set out the support that they're offering, or any reasons why they can't offer support. And one thing to remember is that I think that letter will be stronger if, rather than repeating testimony provided by the applicant, the letter says that the organisation has assessed them as being a victim of domestic abuse or domestic violence, if of course that's the case. So if you can get an assessment, then that's better. But again, I wouldn't delay making an application for a long time to get that evidence, because if you provide the evidence of domestic abuse or violence that you can kind of reasonably get within a relatively short period of time, and the Home Office decides that that's not enough, they should give the applicant a further reasonable opportunity to get further evidence. The next slide sets out some evidence that the domestic violence and abuse guidance suggests might be moderate evidence. And then the following slide sets out evidence that it considers will be weak evidence. And I'm not going to go through all of those now. I've already mentioned that I think in the context of late applications, some of the evidence that might be regarded as weaker in other contexts ought to be accepted, because it would be for other grounds for late applications. So just moving on to the next slides. The next category of people who will be accepted as having reasonable grounds for making a late application are those that can show that there are other compelling, practical or compassionate reasons why they didn't apply to the EU settlement scheme before the deadline that was applicable to them. And there are various examples and suggested evidence and support at pages 42 to 44 of the EUSS guidance. So the first sort of set of examples given, which is at page 42, is that the applicant lacked awareness that they needed to apply by the deadline, or that there were technical or language issues that stopped them from applying by the applicable deadline. So for example, if they didn't have internet access, or they didn't have sufficient digital or language skills to apply by the deadline. And the Home Office says in relation to those sorts of examples, the evidence that could be provided in support include a letter from a relative or carer or care home that the person's personal circumstances, etc., meant that they were unable to apply by the deadline applicable, or evidence that the person was outside the UK in the months before the deadline applicable to them and didn't realise. Then the next slide sets out some more examples. So they include, where a person might had a lack of permanent accommodation, which meant that they lacked access to a computer or necessary documents, people who had complex needs and weren't aware of support that was available to them, people who are hampered in accessing support that was available to them because of COVID-19 restrictions, or, and this is quite a large one that might catch lots of people, people who overlooked the need to apply or overlooked the deadline, or simply failed to get around to applying by the deadline in light of their personal circumstances. So that's quite broad and could apply to a lot of people. Another example is if they've lived in the UK for a significant period of time and having done so didn't realise that they still needed to secure status under the EU settlement scheme, or people who needed a paper application form in order to apply and didn't request it until shortly before the relevant deadline and didn't get it in time to apply in time. So really broad circumstances that might be accepted as reasonable grounds for making a late application. And then in relation to these examples, the EUSS guidance says that evidence and support could include a letter from a charity or homeless shelter, information from the Department for Work and Pensions, or information from the person themselves, for example, about the attempts that they made to try and access support to make an application. And then finally, other examples given under this heading include the applicants having been unable because of compelling practical or compassionate reasons, including relating to COVID-19, to obtain the evidence that they needed of their identity and nationality to make an application. And the EUSS guidance suggests that evidence in support of this could include a letter from a local authority, charity, homeless shelter, etc., confirming the person's circumstances, or information from the person themselves about the attempts they made to get the required documents. The guidance also says there may be reasonable grounds where a person was released from prison after the deadline applicable to them. And it says that there will normally be reasonable grounds where the Home Office is satisfied that when they were in prison, they lacked ready access to immigration advice, or they had reduced access to relevant documents required, or they were awaiting a decision on whether they were going to be deported. And in relation to these circumstances, the EUSS guidance suggests that the evidence that could be provided in support includes information from HM Prison and Probation Service, or the equivalent services in Scotland and Northern Ireland. The next slide looks at people who are exempt from immigration control. As Hannah said in one of the earlier slides, some of those people will have a later deadline than the 30th of June anyway. I'm not going to go into this in detail here. If you have someone who was exempt from immigration control or is, then look at pages 44 to 45 of the guidance for more detail, and you can always get in touch with us as well if you want. Then the next slide looks at people who have existing leave to enter or remain in the UK. And again, I mean, I've put some detail on this slide, but I'm not going to go into it here in any great detail, but you can find out more on pages 45 to 46 of the EUSS guidance. The next slide looks at people who've got existing indefinite leave to remain, and there's information about that on pages 48 to 49 of the guidance. One thing to just point out here is that if someone's got indefinite leave to remain on another basis, so outside of the EU settlement scheme, then they don't have to apply to the EU settlement scheme. They've got no requirement to do that, but they can do so if they wish, and they might want to do so because, for example, if you've got indefinite leave to remain under the EU settlement scheme, often referred to as settled status, then you can spend longer outside the UK without losing that status than you could if you had indefinite leave to remain on another basis. So under the EU settlement scheme, you can spend 5 years outside the UK without losing settled status, but under some other forms of indefinite leave to remain, you can only spend 2 years outside of the UK. So there might be benefits. And what the guidance says is that people who've got indefinite leave to remain can make a late application if the Home Office is satisfied that there are reasonable grounds for them missing the deadline of the 30th of June. So, for example, because they weren't aware that they were eligible. So this isn't really a separate ground, but it's just for showing that you've got reasonable grounds. But I guess this part of the guidance just emphasises that everything we've talked about also applies to people who've got existing indefinite leave to remain and who want to make an EU settlement scheme application. Then just moving on to the next slide, again, this isn't really a separate category of people who might have reasonable grounds, but the guidance just highlights the fact that if there were people who had a residence document under the EEA regulations, so the regulations that used to give people who are EEA nationals or their family members a right to reside in the UK, if they have one of those documents, then they might not have realised that from the 1st of July, they could no longer rely on an EU law right to reside in the UK and needed to make an EU settlement scheme application. And the guidance says that they can make a late application if they have reasonable grounds for missing the deadline. For example, if they weren't aware of the need to apply. And then moving on to the next slide, Hannah mentioned earlier that there are some issues relating specifically to people with a Zambrano right to reside. This isn't yet set out in the guidance expressly, but in a relatively recent case called Akinsanya, the High Court found that rules in Appendix EU and guidance on Appendix EU, which exclude EEA citizens, sorry, it shouldn't say EEA citizens, which exclude people with limited leave to remain in the UK from getting status as a Zambrano carer or dependent under the EU settlement scheme are unlawful. So what the rules and the guidance say is, if you would otherwise meet the definition for being a Zambrano carer, so the primary carer of a British citizen who would have to leave the territory of the UK and the EU if the primary carer had to leave indefinitely. So you've got someone who otherwise meets that definition. They're excluded from getting status under the EU settlement scheme if they have leave to remain under another part of the immigration rules or outside of the immigration rules, limited leave to remain. And what the decision in Akinsanya is that exclusion was unlawful. But the Secretary of State has appealed to the Court of Appeal. And in a consent order that was made in those legal proceedings, the Secretary of State kind of agreed to a number of things. So one of them was that she said that she intends to implement and publicise under which, for a reasonable period of time, Zambrano applications made on or after the 1st of July will be deemed to have reasonable grounds for being late. And she said that that reasonable period will be no less than 6 months after the Secretary of State publishes a reconsideration of the relevant Zambrano rules and guidance. Now, we don't know when she's going to publish that reconsideration, but it's very unlikely to be before the Court of Appeal has decided the appeal. And the Secretary of State agreed that before the expiry of that reasonable period, where people who may be eligible under the EU settlement scheme on the basis of a Zambrano right to reside are encountered by immigration enforcement on or after the 1st of July, they too, just like other people, should be provided with written notice, giving them the opportunity to make a valid application, normally within 28 days of the date of the written notice. So Zambrano carers and dependents on Zambrano carers should have reasonable grounds for making a late application during that reasonable period. Sorry, no, I have finished that slide, Hannah. And then just to end, there are some key takeaways from this late applications guidance. So the first is, it's not too late to support applications to the EU settlement scheme for EU nationals and their family members. And as you've seen from some of the foregoing slides, the circumstances in which people may have reasonable grounds for making a late application are potentially very wide, although for some of those grounds, the longer they leave it after the deadline, the harder they will find it to show that they still have reasonable grounds. So they should apply as soon as possible. Obligations on local authorities to make applications on behalf of looked after children in their care continue to apply beyond the 30th of June 2021. So local authorities still need to be identifying and supporting anybody who needs to apply but hasn't yet to make an EU settlement scheme application. So too do their obligations to inform and support other categories of individuals. So for example, care leavers. Those obligations also continue beyond the 30th of June. And finally, where submitting a late application, where they're submitting a late application on behalf of a child in care, the decision maker doesn't need to consider the reasons why the local authorities failed to apply by the relevant deadline. The fact that they haven't applied for the child by the deadline should constitute reasonable grounds in itself. So that takes us to the end of our slides. Thank you very much, everyone. Don't know if anybody's got any questions. Can't see any. I can't see any questions, and no one seems to be asking any. Oh, Great, thank you. Yeah, well, if anybody does have any questions or needs any support with late applications, then please do feel free to get in touch with us. If you email info@aircentre.org, then your requests will be picked up and looked at. So please feel free to get in touch.